I think most Africans do not like to talk about death matters because they are sensitive matters. But I think it's something that we can never ignore in this day and age. Now, the presentation that I prepared is organized in the following fashion. As many of you are aware, recently Botswana passed a new legislation, the Retirement Funds Act. It deals with many areas, and it seeks to comprehensively regulate many aspects of pension funds that were never regulated before, from investments to death benefits to governance of how pension funds should be governed, how even the players in the industry should operate. It seeks to regulate all these areas. But today we want to focus on one aspect of the regulatory framework that has just been passed and due to come into effect in April of next year. So I want to talk about that framework, and I want to talk about specifically the powers and the responsibilities that have been conferred on the trustees of pension funds who have been given specific powers and duties to perform. And then I also want to touch just briefly on the impact of this new framework on the Matrimonial Causes Act, particularly in relation to divorce matters and so forth. We'll touch just briefly on that. And then lastly, we'll talk about deductions and maybe aspects of the possibilities of withholding benefits when a member of a pension fund dies. So the Retirement Funds Act was passed last year, and the regulations of it were also released sometime last year, and I know that many of you are probably now working towards complying with the new framework. And these changes that are coming into effect are part of a broader financial services reforms that Botswana started to implement over a decade ago. When the NBFIRA Act came into effect, there are aspects of the NBFIRA Act that required that many other aspects of the financial services sector in Botswana should be amended and to comply with the NBFIRA Act. And one of those aspects is the pension funds sector. So many aspects, including the banking sector, many aspects of the financial services sector is under reform, or to try to comply with the precepts in the NBFIRA Act. Now, the death benefits are regulated now in terms of the Retirement Funds Act, or the RFA, in Section 38 and Section 39 of the RFA. And then again in the Regulation 29 of the RFA is where you find provisions that are regulating these aspects. So Section 38 of the RFA provides in the relevant parts as follows. It says, and I quote, "Notwithstanding the provisions of any written law relating to insolvency, if an estate of a person is entitled to a benefit payable in terms of the rules of a fund, such benefit shall not be deemed to form part of the assets in the insolvent estate, and may not be attached by the trustees or the insolvent estate or the creditors." So basically what this means is, it says, is that whenever Parliament starts a sentence in a provision of the law with the word "notwithstanding," what they're trying to say is that we're overriding anything else that is said in any other law. So regardless of what is said in any other law, what we're about to say is what the law shall be. So in this context, they are saying that An estate, a benefit that is payable from a pension fund shall not form part of an estate of the person to whom that benefit is to be paid. So when all of us are going to die, there's a law that governs how those wealth that you have accumulated in your lifetime, including monies that you have paid, that somehow those assets must be distributed in some fashion or another. And so people that you owe money to, creditors, the estate, all of them have access to those assets to get what is due to them that you would have owed to them in your lifetime. But what this provision is saying is that only in relation to death, the pension benefits, the creditors, your estate, do not own the pension benefits because those benefits are excluded from your estate. Okay? That's the first part of how the RFA regulates the death benefits. The second part is in Section 39. It says that subject to Section 38, which we've just read, any benefit payable by a pension fund upon the death of a member shall not form part of the assets in the estate of the member. Now here, as you can see, it's very clear. It spells out clearly that the assets in your pension that you have accumulated are not part of your estate. They are excluded. Let me go on. But they shall be paid to the dependents and nominees designated in writing. The operative word here, designated in writing, to the fund by that member before his or her death, in such proportions as the board deem equitable. Okay. Then it goes on to say that, provided that if the board does not become aware of any dependents, and two, the member has not designated a nominee, or nominee has been designated to receive only a portion of the benefits, then the balance of the death benefit shall be paid to the estate of the member. So what does it say? Your pension benefits as a member do not form part of the estate. That's the first thing we need to get out of this. The second thing we need to get out of it is that those benefits will be paid to the dependents and nominees of the member. Okay? And then the third thing we should get out of this is that those nominees must have been designated in writing to the pension fund by the member before his death. So a nomination cannot appear after the member has died, right? It has to be there before you pass on. And then lastly, if the member died, did not have any dependents, did not write down who he or she wants the benefits to go to. So in other words, the member died with no dependents, with no wishes as to what must happen to their member. Then at that point, the benefits can go to the estate. Or if the member died without any dependents, but had written a nomination form and had only allocated a certain percentage, let's assume it's 50%. So the member said, had no dependents, but wrote down to say, I want, Thabo Druli to receive 50% of my benefits. Then the fund is going to pay that 50% only to that person who was designated in writing. And the remaining 50% will then go to the estate of that deceased. Now, Section 39 and Section 38 must also be read together with the definition of a dependent and the definition of a nominee, which is contained in the RFA. So we need to understand, well, what is a dependent? What is a nominee in terms of how those terms I've defined in the Act. So Section 2 of the Act defines the dependent as follows. A dependent means any person in respect of whom the member is legally liable for maintenance. Right? That's the first part. So here, as you know, people that we are legally liable to maintain are our children, our spouses, and children here means children that may be biological children, they may be adopted children, right? Or even a child that yet to be born. So a child in the womb has not yet been born, but the member dies before the child is born, you are still legally liable to maintain. So those are the type of people that are contemplated in that in subsection A. So a factual dependent is defined to be a person who was financially dependent on the member at the time of death. So that's also a dependent. And then in subsection C it says a dependent means a person in respect of whom the member is not legally liable for maintenance, if such person was in the opinion of the board of the fund now, was dependent on the member for maintenance at the time of death. Now the operative word here, as far as subsection C1, is that the person becomes a dependent based on the opinion of the board. So it is the board that decides whether the person is a dependent or not. The spouse of the member. Now that's very clear. If you're a spouse, you're a dependent, right? It's very easy to prove that you're a spouse. You show your marriage certificate, right? You show evidence that you're a spouse, whether you've married under civil law or whether you're married under customary law. But if you are married to a person, then you are a spouse and you are a dependent in terms of this definition. And then lastly, a child of a member. So a child, whether the child was born in or outside wedlock, a child is a child and is a dependent. Right? So a child is a dependent in terms of the law. Now, the last part, subsection D, says that a dependent means a person in respect of whom the member would have become legally liable for maintenance had the member not died. Another dependent under subsection D would be a fiancé, right? A person that you would have become somebody that was due to get married to the member, but because of the death, the marriage did not happen. Had the death not occurred, that deceased or the surviving individual would have become a dependent, right? I hear a lot of murmurs because I'm sure you're surprised at how could that be, but there are some court decisions that have been decided under this where they have been found to be a fiancé has been found to be a dependent under subsection D. So that could potentially be a dependent, right? Parents or grandparents could also be potentially dependents under subsection D. Now, I think you begin to get a picture that a dependent, as understood in the Act, is not a word that means in our everyday language. It's a term of art. It's a special word under the Act. And it has different consequences under the Retirement Funds Act, unlike in other pieces of legislation that you might know. The other definition that we need to understand and just have a grip with is a nominee. A nominee is also defined. Remember, Section 39 says benefits must be paid to a dependent and nominee designated in writing. So nominee is defined to be a person other than a dependent, nominated by a member as a beneficiary under a fund. So a nominee is not a dependent. A nominee is a person that a member nominates in a beneficiary nomination to receive benefits. So we need to understand the difference between these two wordings, because they have different legal consequences in the context of distributing benefits. But the Act also defines a beneficiary. Now, a beneficiary is defined to be a dependent and a nominee. So a beneficiary means a person who stands to benefit from benefits in terms of the Retirement Funds Act. But a nominee and a dependent have different meanings. So we need to be able to distinguish these two wordings in terms of the Act. Now, I also mentioned Regulation 29. Now, Regulation 29 goes a little bit more deeper, because this is, as you know, regulations are where you find the operational wordings to legislation. So Regulation 29 provides the following. First of all, it requires a pension fund to ensure that members of the fund must complete a beneficiary nomination when they enter the fund, when a member's dependents change, or when a member changes his or her nominees. So it's a legal requirement now that pension funds must ensure that members must have in place a nomination, a beneficiary nomination. It's no longer something that we can do because we feel like it. It's a legal requirement. And the pension fund, and that means trustees of a pension fund, have a legal duty to ensure that there is always on record an updated beneficiary nomination. Secondly, a member of a fund is obliged, has a responsibility to complete a nomination. So not only is the board of the fund required to ensure that there's a valid nomination, beneficiary nomination, but the member himself is also required to ensure that there is in place that you complete a beneficiary nomination. And the regulations prescribe what you must actually put in that nomination. You have to state in that beneficiary nominations who your dependents are, who your nominees are, and how much you want them to receive. Now, obviously, you might not know how much you have accumulated pension credit in your fund, but you can state percentages. I want my spouse to receive 50%. I want my child to receive X percentage. But you have to state the percentages that you want them to receive. And you can provide reasons why you want those particular individuals to receive those percentages. Lastly, Regulation 29 says that if the board receives, at the time now, the member has died, now the board is now at that stage where it has to distribute those death benefits. If the board believes that that beneficiary nomination does not exclude any dependents, or the dependents of that member are included in that beneficiary nomination, and they also believe that that beneficiary nomination is not unreasonable, they may pay according to that nomination. In other words, they will be obliged to pay according to that nomination. In that sense, that nomination becomes binding on the fund. However, the corollary to that, or the opposite, the contrary to that, is if the board finds that or believes that the nomination that is before them does not contain all the dependents of that member, or the distributions that are contained in that nomination are not reasonable, then the board has been given the discretion to ignore that nomination and to pay according to what they believe to be fair.